Welcome to another edition of Disability Law Show. Good to have you along again this week. John Scholes here, hosting as always, and with me from Samfiru, Tumarkin LLP, the most positively reviewed disability law firm in this nation of ours. James Fireman here over the next half hour to answer all of your questions. You want to correspond anytime. When the show's not on air, here's how you do that. Give you a phone number, 1-855-821-5900, help@disabilityrights.ca. We will refer to that email throughout the show, and another website you can use anytime, mydisabilityquestions.com. On the show today for you and James as well, 5 things about LTD claims that everybody should know. So we will enlighten you in just a bit. Lots to get through. We always get started with something that's been, well, you've been dealing with for the last couple of weeks, pal. What's going on?
Well, so I'd like to start off the show. I always like to start off the show by talking about an issue that I think is going to resonate with a lot of our viewers out there. And so this is about the decision about when you should go back to work and who you should listen to when it comes to medical decisions. And the decision to go back to work or not is very much a medical decision. It is not a legal decision. And so if you are getting conflicting opinions from your doctors and your lawyer, or your doctor and your insurance company, your doctor wins.
Right.
Your doctor is the person that you, or your doctors it's the person that you listen to in order to make that kind of a decision. So I have a client who has a cardiac condition. He's a heavy machine operator, and he was approved for long-term disability for the first 2 years. The insurance company accepted that he was certainly disabled because of his cardiac condition from being able to do his own occupation. But after 2 years, they cut him off, and they said that he was able to do another job. His GP and his cardiologist both wrote to the insurer prior to the denial saying he is not capable of doing any job. Any additional stress can cause a cardiac event. Essentially, he's risking his life.
Yeah.
Right? That is exactly what it means. If he goes into work, whatever the job is, it's going to be literally risking his life. And the insurance company knew this, and I know that because I have their file, and it's repeated at least a dozen times in their file, that going into any job could cause a cardiac event.
Could kill him. Yeah.
But they still denied the claim, or they told him that he was going to have to go back to work. And it's in the file, but they justified it by saying that he's functionally capable of going back to work. In other words, yes, he's risking death by going into work, but he could still do it up until the point he dies. That's essentially the argument that they're making. And obviously that's not an argument that's going to hold up very well if it's in front of a judge. And the reality is the policy certainly doesn't allow them to do that, because the policy entitles you to benefits if you have restrictions or functional limitations that prevent you from being able to go to work. And he certainly had a restriction, as articulated by his family doctor and his cardiologist, that he cannot do any work. As an aside, he also was not functionally able to do it because he's got a back issue that prevents him from sitting for more than 20 to 30 minutes at a time. And even if he could, he doesn't have the qualifications to earn the commensurate income that would be required in order for them to actually justify it. So the insurance company, in every way possible, has failed my client in this case, and they're going to pay for it. They're going to pay for it in a really big way. And they're not going to just have to pay the benefits, which they're going to have to pay. They're also going to have to pay punitive damages. They're going to have to pay something on top of what they already owe my client for his benefits because of the way they handled the claim. They know very well if they challenge me now, then we're going to wind up in court. And not only are they going to have to pay the benefits, not only are they going to have to pay punitive damages, but it's going to be public and it's going to be very embarrassing for them.
They has a medical team. I mean, he's risking death. What else does the insurance company need to know? Or it's not about that.
I can't answer that question. You're asking me to apply logic where logic is not being applied. There isn't a justifiable answer for it other than the insurance companies are going to take anything they can to justify cutting off your benefits, because that's what they're there for. When you are applying for your benefits, when they're adjudicating your claim, the claims handlers that are making the decisions on your case, their objective is to find a justification to cut off your benefits, because that's how insurance company makes money. That they make their profits by paying out as little as they possibly can. They take in as many premiums as they can, pay out as little as possible.
Business.
So if your job is a claims handler, how do you help your company? How do you impress your bosses? By cutting off as many claims as possible. That is what their objective is. And so they're going to look for anything that they can. And whether or not there's very clearly no basis to justify it, they'll cherry pick what they can, and eventually they're going to cut off your benefits.
Is there ever a time, maybe not in this case, it seems pretty cut and dry, but is there ever a time where maybe even with the medical documentation, you're not, you always say in the show, you're legal, you're not medical, but Do you ever have to give maybe the medical team a nudge saying it needs to be a little more robust than just a scribble on a napkin, or maybe you need to add a few more notes to it? Would that change the mind of the insurance company?
Usually not. Usually once they've already made their decision,
Right.
then they're not going to go back on it. Occasionally, though, I'll have clients come to me and then they'll have their application denied by the insurance company for a lack of medical information, and I'll take a look at the file and I'll say, you know what? They're probably right. I understand why they've done that here. It may not be that you're not disabled, but your doctors haven't properly documented that. Or perhaps, you know, you've only seen your GP, but it's something where a disability of that nature would require somebody to reasonably seek treatment from a specialist.
Right.
They haven't done that yet. It doesn't mean that they can't actually have their benefits eventually reinstated and put back on claim, but they're going to have to take steps to make sure that they're getting all reasonable treatment that they should. So occasionally, you know, the insurance company can be justified in doing that, but the cases that reach me are rarely that situation.
There is a website you can use anytime called pocketemploymentlawyer.ca. I mean, the other half of the firm, of course, is employment law, but within that website, there's a pretty good section on disability law. Again, this is just another avenue for you to learn more about your particular case or someone you know is dealing with an insurance company. Pocketemploymentlawyer.ca is the way to do that. I want to get onto an email here, James, before we get into a break. For the first time today. Again, help@disabilityrights.ca. This time around, Sarah says, I was in a car accident a few years ago, and since then I've had excruciating migraines and constant back pain. As a project manager, this prevents me from being able to work. I've been approved for CPP disability, but my insurance company says that I no longer meet the criteria for LTD, so they're cutting me off. How is this possible, and what can I do?
Really interesting situation,
Yep.
Sarah. So let's take a quick step back and understand exactly what's happening here. Sarah has applied for both long-term disability benefits and CPP disability. Usually on the show we're talking about long-term disability benefits, but CPP disability plays a very big role in the long-term disability benefits process. So CPP disability is a program that's administered by our federal government. And if you've been paying into CPP, if you've been getting deductions off of your paycheck every week for CPP, then you're entitled to apply for CPP disability if you have a prolonged and severe disability that's preventing you from working. That's the CPP disability test. Now, if you were to compare that test, a severe and prolonged disability, to the standard test in a long-term disability claim, which requires a disability that's preventing you from doing your own occupation. Severe and prolonged is a more onerous test than the LTD test. If you pass the CPP disability test, you should, by definition, also pass any standard test in an LTD policy. You should be entitled to both if you get CPP disability. Doesn't necessarily work the other way. There are many situations where people will be entitled to long-term disability because they have a disability preventing them from their job, but it's not yet a severe and prolonged disability. So you can be just LTD, but I can't understand a scenario where you would be just CPP disability.
Gotcha.
If you get CPP disability, you should be getting both. So that is excellent evidence in and of itself that you're entitled to the disability benefits. So what do you do about it? We start a legal claim, and that is the very first argument that I'm going to make. How can you tell me that my client isn't entitled to long-term disability benefits, which is an easier test than the CPP disability benefits test, where our government is saying my client has a severe and prolonged disability? How can you possibly justify that? And they can't.
Is it not a good thing for somebody to, well, I mean, we often talk about on the radio show as well that they'll be forced or at least asked to apply for CPP by the insurance company, but that's a good thing. Can it not be for several reasons? Yeah,
so you have to understand, even if you're approved for CPP disability, it doesn't increase the total amount of money that you're going to get. But there are some real big benefits from that. Number one, what we've already talked about, it strengthens your LTD claim. So Sarah's talking about a very unusual situation where the insurer has denied despite a CPPD approval, despite a CPP disability approval. That's unusual. Most cases, the insurer knows once you get approved for CPP disability, they're pretty much going to have to pay those long-term disability benefits. So that's the first thing. Number two, in Sarah's situation, she is getting part of the benefit from it because even though her LTD has cut her off, she's continuing to get her CPP disability. She's continuing to get a portion of what she's entitled to. So there are really good reasons for it. But the third reason is you're required to do it under the policy. Almost every long-term disability policy requires you to apply for CPP disability.
Because?
Well, if you don't do it, what the insurance company is going to do is they're going to say, well, had you applied and been approved, this is what we estimate your CPP disability would have been, and we're going to take a credit for that. If you apply and you're denied, that's fine, because you can be denied CPP disability and still be entitled to your LTD benefits. And then in that situation, your insurance company can't turn around and say, you haven't applied, so we're deducting it anyway. You've applied, you've been denied, there's no argument they're entitled to a deduction. But if you haven't applied, they will say, we're entitled to this deduction, so we're just going to reduce your LTD payment by $1,000 or $1,400 or whatever they estimate that benefit to be.
So just to be clear, you may have these two income streams. Say LTD is paying you $2,000 and the CPP starts paying you $1,000. Well, the LTD is going to claim that $1,000, so you're still making $2,000.
Yep, it's still the same amount as you had been before. It's not going to increase the total amount of money coming in, but there are a lot of good reasons why you want to do it, not the least of which is you're required to.
Coming up, 5 things you need to know about LTD claims. A short break first. We'll get into that right now. 1-855-821-5900. Help at disabilityrights.ca. Don't go anywhere. Lots more Disability Law Show is just ahead. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back, Disability Law Show. Good to have you sticking around. John Scholes here, James Fireman as well, Samfiru, Tumarkin. That is the law firm, most positively reviewed disability law firm in the country. How about that? Okay, 5 things you need to know and you should know about LTD claims coming up right now. First one is this, James. Insurance companies routinely deny LTD claims unjustly and unfairly. These denials can be successfully fought.
Yeah, the majority of people who have their claims denied don't challenge the insurer or only do an appeal, which means that they really aren't forcing the insurance company to do much of anything. Even when their doctors are telling them that they can't go back to work, they're going to accept the insurer's decision. You can't do that. If you've been denied your benefits and your doctors have told you that you're not able to go back to work and you know that you can't go back to work, don't accept what the insurer is saying. Start a legal claim and force them to pay you the benefits you're entitled to.
What's the reason? I mean, I would start one because I know you. I've known Savannah for 10 years. We've been doing this show. I wouldn't take it. But is it a matter of fear? Well, it's the big bad insurance company. It's the David and Goliath thing, right? What chance do I have against, saying what they say is right?
I think that's certainly true for a good chunk of the people that don't, but it's multifactorial.
Yeah.
For some people it's fear. For some people it's just a lack of information. For some people it just might be confusion or misunderstanding, or it could be all of them. And that's really intentional. The process is intentionally difficult to understand and confusing, and we're going to see that as we go along. But the insurance company designs the process to make it seem as though there really isn't much that you can do. If they say that you don't have the right to get your disability benefits, then there's not a whole lot of point in challenging them. That's what they want you to think. Don't believe it.
Number 2 is this. Insurance companies often deny claims on the basis that individuals are not, quote unquote, totally disabled. Totally disabled, of course, an invented term that has its own special meaning in the context of LTD.
And this is how you know I actually read the show notes in advance. I was referring to this in the first segment, in the first part of this series. Totally disabled is an invented term that is meant to confuse you.
Oh, yeah.
So Totally disabled, if you're talking about totally disabled in the context of your day-to-day life, if you're saying that someone you know is totally disabled, most people are going to interpret that as meaning the person is in bed all day. They can't function. They can't go do grocery shopping or household tasks. They're just unable to do pretty much anything. They are totally disabled.
Right.
In the insurance context, that is not what it means at all. The only thing that it means is that you are not able to do the tasks of your own occupation because of a medical disability. It only refers to your ability to do your job. And depending on what your job is, it may not be very descriptive of your level of disability. In other words, if you have a very physically demanding job and you have an injury that prevents you from doing it, you may still be able to do all kinds of things, just not your occupation that you had before. So totally disabled has a very specific and narrow meaning when we're talking about disability law. But they call it total disability because it's confusing. Because they can write to you and say, we're denying your benefits because we find that you are not totally disabled. And a lot of people will receive that letter and they'll say, well, I guess that's right. I'm not totally disabled. I can get out of bed. I can get myself dressed. I can make my breakfast. I can go do my grocery shopping. So I'm not totally disabled. I guess they're right. I guess I'm not entitled to benefits. That's not what totally disabled means in the disability context. You're still entitled to your benefits if you have a disability that is preventing you from doing your own occupation.
Which is why number 3 is so important, and that is LTD benefits are available not only to claimants with physical disabilities, but also claimants who suffer from mental illnesses as well.
Yeah, this is huge. I would say, I think the last time I saw the statistics on this, it was between 60 and 70% of LTD claimants have either a primary or secondary mental health disability. So it's playing a very huge role in the majority of LTD cases. And that's why I talk about on many shows that it's something that the insurance companies are coming to grips with. They're starting to understand it better. There is still a gap between how mental health claims are treated and physical health claims are treated, but it is thankfully narrowing. But if you're suffering from depression or anxiety or other mental health issues, don't think that because there isn't a x-ray that shows that you have this particular disability that you're not entitled to benefits. You are. Long-term disability policies entitle you to receive benefits if you have a mental health disability that's preventing you from doing your own occupation.
And have you found some of these things can play off each other? I mean, what starts with a physical disability, they're off for 2 years. They're totally disabled underneath the policy. I mean, after a while, that can dray on you. It become a mental disability, can be enrolled in with it, with medical documentation too, I guess, right?
I would say that's actually the expectation.
Yeah.
More often than not, when someone has been disabled from work for an extended period of time, there is going to be some mental health issues there. It may not rise to the level of a diagnosable condition. Sometimes it definitely will, sometimes it won't, but it certainly is a factor that can complicate recovery from a physical disability. Absolutely, we see that all the time.
Number 4 out of 5 things you need to know about disability claims is this one. Individuals have 2 years from the initial date of denial to pursue a legal claim for compensation for LTD.
Yep, that is a real important timeline to keep in mind because the clock starts running as soon as you get that letter from your insurer denying your claim. From that point, you have 2 years to start a legal claim, and that is the window to get things done. If you don't start a legal claim in that period of time, you will have no recourse. Your insurance company is not going to talk to you about the legal process or about bringing the claim in the 2 years. Sometimes they'll put a brief note at the bottom. But what they're going to do in a big heading is they're going to talk about the appeal process and invite you to do that. It is a waste of time, the appeal process. I've talked about appeals ad nauseum on this show. Don't do it. All the insurance company is trying to do is waste your time and dry out those 2 years. They want to run out the clock on those 2 years. And once it's done, they're not going to be interested in hearing your appeals anymore. They'll hear as many appeals as you want within those 2 years, but as soon as that 2-year clock has expired, not anymore. They don't want to hear from you.
Number 5 simply wraps it up with a nice bow neatly for you, James. If LTD is denied, you should contact a disability lawyer as soon as possible because, as you just mentioned, time is of the essence, right?
Yeah, absolutely. So, one, you want to make sure that you're aware of that 2-year limitation period, but even putting that aside, when you've been denied your LTD benefits, it means, number 1, you don't have any income coming in, and number 2, you don't have any disability benefits coming in. So for most people, it means that they are in very difficult financial circumstances. And the longer you wait to start your disability claim, the longer it's going to take until you get to resolution. And so if you want to relieve that financial stress, you want to make sure that you start the legal process as soon as you reasonably can. And that can start as soon as the insurance company writes you that letter. Even if they write to you and say, we're cutting you off at the 2-year mark.
Just going to ask you that.
Yeah, I knew you were.
Yeah.
Even if they write to you and say, we're going to cut you off 6 months from now at the
Make the phone
2-year
call.
mark, as soon as you get that letter where the insurance company is positively telling you that they're cutting off your benefit at this point in time, you can start your claim right then and there. You're entitled to start your claim then. And when you do that, you give yourself a much better chance of getting a resolution before your benefits run out, or at the very least, not long after that. So there isn't this long period of time where you have no benefits coming in and no settlement money.
If you do get somebody, if they've been cut off, you get involved, they get back on claim, is there a certain amount of time you're talking about before the money starts kicking in again? There's a term for that, no?
Well, so typically speaking, if we get involved and they put the person back on claim, it's going to start right away.
Nice.
All they're going to do is they're going to pay everything up to the date where we get the resolution and then put you back on claim on a monthly basis.
Right.
That's a little bit more unusual. More often than not, when we resolve claims, we do it on what we call a full and final basis, where the insurance company is paying everything they owe up to date, and then they're paying several years into the future to account for what we can show the medical evidence suggests is likely going to happen down the road. For how many years my client is not going to be able to work beyond the date of the resolution.
After these 5 points, if you still have some of those what-if questions, here's a way you can ask them. Make a phone call. Talk to James' team as we get to a break here. 1-855-821-5900. help@disabilityrights.ca is a good way to do that. And mydisabilityquestions.com will continue. Disability Law Show. Hang on. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thank you for hanging out for the remainder of the show. Disability Law Show. Every week you catch us, myself and James Fireman or Tumarkin doing the show, educating you on disability law and disability rights, which you have. So don't ever fear making that phone call, 1-855-821-5900. Another resource, mydisabilityquestions.com, free website. Use it, ask your questions. Gregory did exactly that, James. Gregory asked, he says, if someone is unionized and their union refuses to help them with their long-term disability claim, can they get help from a disability lawyer?
More often than not, they can. And this is a situation we unfortunately see far more often than I would like to share. Unions typically are not concentrating on long-term disability.
Sure.
It is actually far less common to find a union that actually has someone dedicated to that task who really understands the process and is capable and qualified of providing sound advice to their union members. More often than not, we find union members who get no help or almost no help from their union and just don't know what to do and are sort of left to their own. So if you are part of a union, a lot of people are going to call us and say, is Samfiru Tumarkin able to help us? More often than not, the answer is going to be yes, we can. In order to figure that out, all we need to do is take a look at the collective bargaining agreement. And the vast majority of unions have their collective bargaining agreements online, available for all their members. So it's actually a really easy thing to send that to us. And it takes about 5 minutes, maybe 10 minutes at the most, for me to go through that collective bargaining agreement and figure out whether it is something that I'm entitled to help you with. You don't really need to understand the nuts and bolts of it, but really there are some collective bargaining agreements that would prevent an outside lawyer from getting involved. There'd be a process in there that you would have to go through if you were disputing the insurance company's determination. But that's more the exception than the rule, especially in Ontario. In BC, it's a little bit different, but in Ontario, it's generally the case that most union members can hire an outside lawyer and make use of the regular judicial system.
Which is a good thing to clarify, because the other half of the show, we do the employment law show. That's usually not a thing. Your outside law firm cannot help a union member, but disability law is different. That's worthwhile making mention of, right?
Yeah, there is case law that talks about the differences in what situations it's allowable. But what I'll tell you is there are actually a lot of situations where we shouldn't be allowed to get involved, where we're not really supposed to be allowed to, but we will ask the insurance company and the union whether they have any issue with us getting involved. And even though they might have the ability to say, no, you can't get involved, a lot of them will say, no, that's fine, you can get involved, this will be easier for us if you do it that way. And as long as they agree to it in advance, then we're happy to get involved. And so that's something we've actually had a lot of success in. So it's the vast majority of union members we're going to be able to help anyway. And even for those where in most cases we wouldn't be able to, there are some that we can still help them with.
Nice. Yeah. Let's get to an email. help@disabilityrights.ca is that email address. Ian, I'm a tradesman and I've been on LTD for almost 2 years. I was cut off recently and was told that I can either appeal the denial or instead transition to office work. I already have my doctor's support and I'm not sure what else I can do. Should I appeal? What are my options?
Well, if you have your doctor's support and you don't feel like you can transition to another job and your doctor's saying you shouldn't be doing that, then it sounds to me like that's the answer right there.
Yeah.
Listen to your doctors when it comes to a medical decision. And I say it, I think, virtually every time we do a television or radio show. The decision about whether or not to go back to work is not a legal decision, it's a medical decision. And so if your doctors are telling you not to do it, then that is who you should be listening to. If your doctors say don't go back to work, don't risk it. But as for should you appeal or not, no, appealing is a waste of time. So if you're not going back to work and you're not capable of it, and your doctor is supporting you and your insurance company is telling you they're not going to pay your benefits, don't appeal. Start a legal claim and make sure that your insurance company is going to pay what you're entitled to. That's the only way you're going to force them to come to the table.
We'll get to one more. This one from Veronica at mydisabilityquestions.com. We'll bounce back over there. She says, I have a mediation schedule with my disability lawyer and the insurance company and I am very nervous. I've asked my lawyer for information regarding the mediation, but he continued to be very uncooperative. Do I have a reason to worry? I was on LTD for over a year due to a heart condition before my benefits were cut off.
So this is a little bit unfortunate. There is a lot of situations where lawyers are not great at communicating with their clients. Part of our job as lawyers is communicating with the other side, but it's also making sure that our clients understand what's happening, understand the process, know what to expect. And it's a part of the job that every lawyer at my firm takes very, very seriously. And so I would say that is certainly a failing on the part of Veronica's lawyer here. But that doesn't necessarily mean that she has something to worry about. It may just be that her lawyer is not really succeeding in communicating with Veronica, but is prepared and ready to go. I would still insist in that situation, if I were Veronica, that her lawyer communicate in advance and make sure that she understands what the process is going to be like and what her expectations ought to be for mediation. And that is something that I do with every single one of my clients, and it is a practice that the other lawyers at my firm have as well too. We meet with our clients in advance of mediation, and we spend an hour or so making sure that they understand exactly what's ahead. So I'm going to make sure that my clients know exactly what to expect in that mediation, know exactly how the process is going to unfold. And then I'm going to give them my own assessment of their case and get instructions from them so that when we go to mediation, they're not going to have any surprises. There's not going to be a point in there where they're thinking, oh, wow, what the heck is going on? James, you need to help me. No, they know everything that's going to happen. They know everything that's coming. And it's usually a much calmer process for my clients because of that preparation in advance.
And the mediation's a good thing too, right? I mean, that's where a lot of stuff gets resolved, right?
That is the objective of every case, is to get to mediation so they can get a resolution. In the vast majority of cases, that is where it's going to come down to. That's where we're going to get the settlement. That's where my clients are going to get paid.
And that is it for another show. You want to reach out to James? No problem. 1-855-821-5900. help@disabilityrights.ca. That's the email address we use. And again, mydisabilityquestions.com. It's free, anonymous. Go ahead and use it. And we'll catch you next time on Disability Law Show.